The National Assembly on May 15, 2025 passed the historic Oil Pollution Prevention, Preparedness, Response and Responsibility Bill 2025, aka we want to call it the Oil Spill Bill. The bill establishes a national legal framework for managing oil spill risks and liabilities, and it requires responsible parties to bear the full cost of environmental restoration and compensation for damages, even if it goes beyond the cleanup phase. The law sets out a number of mechanisms that the state will adopt to address any spills through the Civil Defense Commission. Although the bill is written in plain and simple language, there has been a deluge of misinformation, riddled with fallacies and flawed arguments aimed at misleading the public. We're going to unpack some of what appears to be a campaign of misinformation with the help of Guyana's Attorney General and Minister of Legal Affairs, Anil Nandlall. Welcome.
Thank you very much.
Let's begin. Every piece of legislation comes with its own unique slice of history. What were the driving factors behind this particular bill?
This bill, Nazim, is long overdue. We have been pumping oil now for several years. It started under the previous government. They did not enact a single piece of legislation for the sector. Not one, although they presided over the country for about 3 to 4 years while we were producing oil on a commercial basis. Not a single regulation did they pass. Not a single policy did they implement in relation to this sector. Any country that is producing oil at the magnitude that we are is enjoined both by international obligation, by local duties and for the protection of the environment and the people generally, must enact a firm, robust, and strong framework that will regulate the sector in every possible way. This is a hazardous sector, no doubt. It can have great potential damage to the environment, to natural life as we know it. Naturally, the state must, in this regard, establish a firm, resilient framework that will ensure that if ever those eventualities are to take place, we have protocols, we have a framework, we have rules, we have laws that will govern every aspect of the issue. We must know who are the responsible parties. We must fix liability in relation to those parties. We must speak to how those liabilities are going to be assured, insured, and guaranteed in the event of failure of the primary party. We must ensure that there is a plan that can quickly be activated, that is comprehensive, and that meets best international practices on the matter. We must ensure that that plan is also in accordance with our international obligations on these matters. We must ensure that that plan exists at the level of the operators in the sector, and that there must be a national contingency plan, and the two plans, or the two sets of plan, must work in tandem with each other. We must ensure that there is a strong mechanism for cleanup and restoration of the environment once the event occurs. We must also ensure that even after an operator leaves and where he was operating, maybe years after, there is an eruption of some type, the last person who operated there must be held responsible. We must fix liability to such a manner that it runs with the damage done, so that there is no cap in liability. And in short, this bill captures all those indispensable prerequisites that are necessary for this sector and that meet international standards. And that is what we try to achieve in the bill, and I believe that we have done so. This bill was crafted by highly qualified persons about a year ago, and then spent a year in Guyana,
Yeah.
being examined and being critically scrutinized by our local experts, the Attorney General Chambers, the Ministry of Legal Affairs, the Environmental Protection Agency, the MARAD, the Civil Defense Commission, and the operators in the sector. And it went through clause by clause of examination.
I want to get to that. Here's a quote from someone who has been spreading a lot of misinformation and writing profusely in the local press. The person says, the bill's 37 clauses and 3 schedules were considered en bloc or en bloc, meaning that no clause-by-clause examination was conducted. One wonders whether the speaker or the mover of the bill wanted to avoid a critical analysis of the bill's provision.
Now, you read that sounds very intelligent, doesn't it?
Yeah.
It sounds that this gentleman here is profound. That is utter nonsense. That author doesn't understand at all how bills are passed in our assembly and the publicity mechanism that is engaged when a bill is to be enacted into law. The unsuspecting public who doesn't know that process would buy into this. And these guys write these things, I believe, because they want public acclaim. So there is a willing press out there that absorbs these things and outputs them in the most sensational way in the front page. And these guys get their photographs splashed in the newspapers. Then you have a political directorate in the opposition that does not read. So they would hold on to that. They and their acolytes would hold on to that despite the profuse ignorance that is expressed there. So let me tell you the process. A bill, first of all, has to be published in the official gazette. So the whole world sees the bill before it reaches the parliament. Then it is read in the parliament for the first time. And it is left on the order paper. In this case, this bill was left on the order paper, I think, for 2 to 3 weeks. Where again the whole world and the whole country would have had an opportunity to examine it clause by clause. Then there is a debate on the bill. The debate in this case lasted nearly 5 hours, where every debater from both sides of the House is entitled to and has the right to examine every clause of that bill in the debate stage. It's not debating a part of the bill. So the entire bill is under review and consideration during that debate process. During that debate process also, any member of the National Assembly has a right to proffer an amendment to anything in that bill, any clause in that bill, because the entire bill is under review. If an amendment is proffered, the bill then, after the third reading of the bill has to be considered in a committee of the Parliament, of the whole Assembly, clause by clause. And if an amendment is on the floor, it is during that examination that the amendment is put and the Assembly votes on it. No amendment was put here. When an amendment is not put in the committee stage, as a matter of practice, there is no need to consider the bill at that stage, again, clause by clause, because there is no amendment coming to any particular clause. So for expediency, for over 80 years, our Parliament has always adopted the procedure of taking all the sections en bloc because there is no amendment. That happens only in the committee stage. And then it is reported in the outer house back that the bill, having been considered clause by clause in the National Assembly, in the committee, no objection came, no amendments came, and the request is for it to be passed as printed. This bill went through that process. So that gentleman there, and that they write with such authority, and they write with such boldness, that I myself would want to question whether something wrong was done. So that's a classic example of the misinformation, misapprehension, and I dare say, and I say with the greatest of respect, unadulterated ignorance being expressed in the public domain.
So in the public domain, the perception from that sentence is that this was just slipped through.
That's correct. There's another one that I can quickly refer you to. Another commentator, and you see they get titles when they write these things, you know. So this particular commentator in the press that publishes what she says describes her as an international lawyer. That by itself is an enigma. Nobody understands what that connotes, this international lawyer, because we don't know where she practices this international law. This person says that this bill is unconstitutional, that it violates Article 149J of the Constitution. Now, again, that sounds very attractive to your cameraman. That sounds attractive to a government critic. Here is a government being accused by an international lawyer, so the presumption is that this person knows what she's talking about. Accused by an international lawyer of violating the Constitution, of passing an unconstitutional law. The truth of the matter is, Article 149J guarantees to every citizen of this country, as a fundamental right and freedom, a clean environment, and imposes on the state an obligation to pass legislation and to implement policies to ensure that the population enjoys a clean environment. First of all, it is the PPP government that put that in the Constitution. That's the first thing. This is the PPP government passing this law. So the first contradiction is, and I said elsewhere, that this international lawyer should cite a similar provision anywhere in the Caribbean in a constitution. They will not find it.
Right.
The PPP government, 25 years ago, inserted that in our constitution.
Pretty progressive.
The argument is, from this international lawyer, is that we are violating a provision that we ourselves inserted in the Constitution. So right there's a contradiction in terms. But more fundamentally, before this bill, we had nothing. We had nothing in relation to the oil and gas sector to which this constitutional provision relates. We have an Environmental Protection Act that was passed in 1996, again by a PPP government, and which is still sound, and which is still in place up to now. But in relation to oil spill preparedness, etc., we didn't have that. So we were in a sense in violation of Article 149 before this bill. This international lawyer never said that. So when the previous government was there and they were pumping oil, they were doing so without any regard to the requirement of Article 149.
Exactly.
Now we have passed a comprehensive bill to which regulations will have to come, and hopefully I get a chance to speak about the regulations. Regulations will have to come, and this bill lays out a comprehensive framework, all designed to protect the environment, to satisfy the requirements of Article 149. So we have moved from zero to a comprehensive bill, but this commentator says that we have violated the Constitution.
All right.
Had the commentator say, for example, that the Constitution sets a standard of, let us say, 100%, and we met 60% or 40%, that's an argument that we can work with. At least there is a recognition that the bill has a connection to that provision. There is no recognition, none. And we believe that the bill meets that standard, the constitutional standard. Let me just, one other point I want to make. We live in a society, unfortunately, where a functional illiterate can contradict the expert opinion of three renowned, internationally acclaimed pathologists on a forensic examination. That is the unfortunate reality of Guyanese society. So that characterizes these commentaries that you are hearing from this commentariat of pseudo-experts and pseudo-intellects. Because everything that they say, Nazim, I can put on the table and dissect publicly every contention that they have made about this bill. Because we sat with this bill and went through it clause by clause. And hopefully, as we continue the program, you will give me the opportunity to
Yeah. I want to cite.
speak.
I want to cite one more quote, and then I'll get rid of the quotations.
No,
And
you continue to quote because I want to answer these these
Absolutely.
baseless allegations. That's the purpose of the program.
So this person writes, and while the bill references substantial penalties, it is silent on enforcement architecture. No inspectors, timelines, or triggers.
The bill sets up an entire architecture of how the bill will be administered. There are different agencies within the bill. It's a structure that starts from the top and it comes down like a pyramid. So at the top you have the Civil Defense Commission. And then that coordinates the entire national and oversees the entire national framework. And then for onshore, you have the Guyana Energy Agency for onshore regulation.
Right.
And then for offshore regulation, you have the Maritime Department, MARAD. And that's the structure. And then, of course, you have the Environmental Protection Agency. And earlier, I made reference to a regulatory framework that will come in the form of regulations. And the minister will promulgate that very shortly. And that, my friend, you see, again, you cannot, it's basic law, it's basic legislative drafting, that you can't put everything in a legislation. That is why you have big regulations that come. The foundation of it is laid out in the legislation. The regulation that will come now will set out all the final rules that will make the act implementable. So all the standards and the inspectorate and supervision that they're speaking about, the base is laid here. So the GA will have a whole regulatory framework that will say how the GA will regulate that part of the responsibility assigned to it by the bill.
Right.
Another set of regulation will speak to MARAD. And that is what they're talking about. But that doesn't have to be in a bill,
Yeah.
or else the bill will be 1,000 pages.
Yeah.
Now, were they... Now, you see, I don't want to be insultive to people.
Yeah.
But persons who hold the qualifications that they hold ought to know these things. These are lawyers, you know, accountants and so on. They are the recipient of tertiary education. And you would think that their thought process would be a little more superior than what is expressed in the public domain.
So let's get to this critical point, and I think this is an important one, because I've read Section 21 of the bill,
Yeah.
of this particular oil spill bill, and it states that an indemnification or any like agreement shall be invalid for the purposes of transferring the liability of a responsible party under this act. Okay, so critics have said that your administration has switched positions on the matter of unlimited liability, since this piece of legislation hands over full responsibility to the entities that may cause an oil spill. What's going on here? Why this colossal misinterpretation of Section 21?
Again, I say it's either a lack of understanding, a lack of comprehension capabilities, or simple wickedness. I can't come up with another explanation. You will agree with me that this section is crafted in reasonably clear language.
Reasonably.
It is succinct. It is clear. It has no words there that is capable of a dual interpretation. I can't detect an ambiguity or an ambivalence. I can't detect any linguistic equivocation. So let's start out with what it says. So the marginal note says no transfer of liability.
Right.
Under our law, you use the marginal note to aid in the interpretation. So a reader, first of all, will look at the marginal note and immediately get an indication of what the cut and thrust of the section is about.
Right.
That's the purpose of the marginal note. And it says that no transfer of liability. What that means, Nazim, is that if you are the primary operator, you are the responsible party, that's how the bill describes it, and you cause the damage, you cause the liability, that liability is implacably attached to you. It's irrevocably attached to you. It is inseparable from you. The intent here is to ensure that what is done in commercial practice does not operate here or doesn't obtain. That is to say, that you have one company here that's operating, and if that company wants to shift liability from itself, assign liability, divest liability, or transfer the liability, then that company is prevented from doing so. Why would you want to transfer liability? Companies do it all the time. They have a company with no assets, and they enter into an agreement with the company with assets. And they say the company with assets assigns all its liabilities to the company without assets, a dummy company. So when liability arises, they hold up that agreement and they said, look, we are not responsible. We have assigned that liability to that company. That cannot happen.
Right.
It is as simple as that. So Exxon Mobil here, or CNOC or Hess, they can transfer their liability to some other company that they established by the side and use that as a cloak to insulate them from liability that may flow from their actions. How is that a bad thing? Now, this has to be read. This has to be read in connection with the other parts of the bill that speaks to financial assurance. These companies, these primary responsible parties, are required under the Environmental Protection Act and under their license, the Environmental Protection License. They are required to have insurance. They are required to have an assurance. They are required to have a guarantor or a surety. They are required to have parent guarantee. So because they can shift the liability, all those things are coming up. And if they are at the bottom of these things are to protect the Guyanese population from any evasion or illusion of liability. Am I not clear?
Yeah.
How?
So how are you reading it the opposite?
I don't know how they're reading the exact opposite. They're reading this the exact opposite. So that this is to keep everything else that they're arguing for in check. So that the company at the bottom can shift the liability anywhere else. So that all the other mechanisms that guarantees the performance of this party at the bottom here, guarantees their performance, guarantees their assurance, and would stand as a surety for their liability, and would guarantee their liability. Those companies are held intact because the primary obligator, because all those instruments, they relate to the primary obligator, and the primary obligator can shift that liability. One person even went as far as saying, Sherwin Holder in the parliament. This man says, he says that we have allowed in the bill the operators here to declare bankrupt and go away, and that dissipates the liability. The bill sets out a whole set of mechanisms to guard against that. They are telling us also that we repealed the EPA Act when the financial responsibility is dealt with in a different part, as I've said in the press release. A responsible party shall maintain and provide evidence of financial assurance to the satisfaction of the competent authority. So you have to have financial assurance. Not only you and what your assets are. You have to have financial assurance.
Right.
Financial assurance is defined. It goes on to say financial assurance shall be in accordance with the Petroleum Activities Act and the Environmental Protection Act. The Environmental Protection Act, they tell you what financial assurance is. It includes insurance, a guarantee, a parent company guarantee, a surety, a bond, a whole list of things. All of which, or one of which, can constitute adequate financial assurance. And it says that the financial assurance requirement under subsection 1 shall ensure comprehensive coverage as far as possible. So the widest coverage that is available in the industry is what is extracted here. And this is the part I want to get to. A person who claimed directly against a surety of a responsible party, if you claim directly, a person may claim directly to the surety. So here, if you can't get to the responsible party, you can go to the surety. And here is how you can do it. If the responsible party who has been found liable to pay a claim under this act has failed to pay the claim. So when the local people here fail to pay the claim, you can go against the surety. The surety, as I said, could be the guarantor. It could be the parent company guarantee. It could be some other assurance fund. It could be a bond. And B, the responsible party filed petition for bankruptcy or has become insolvent. The exact thing that we are saying, if it happens, we can go to the parent company and we can go to the assurance. Sherwin Holder told the Parliament that we are facilitating the company, we are permitting the companies here to declare bankrupt and run away from the country.
Yeah.
This is the type of misinformation that we got to deal with
Yeah.
from purportedly educated people and political leaders. And they do it with a straight face. And what is worse, you have enabling press outfits that gives them the widest and most sensational coverage with this type of diatribe.
One commentator has even gone to the extreme to say that the bill repeals the Environmental Protection Act.
Yes. So I just read it to you. Financial assurance shall be in accordance with the Petroleum Activities Act and the Environmental Protection Act. Financial assurance has the same meaning under the Environmental Protection Act. Clause 27. How are they reading that? How? When the act, the bill says in very clear language that this bill embraces the Environmental Protection Act. And how can I not say, sitting here and speaking to you about these dissemination of misinformation, how can I not ascribe either a motive of mischief or an unbelievable amount of ignorance? I don't know which one, and which one is worse.
All right. Let me ask you this other one here. On section 17, liability. A responsible party is liable for all damages caused by an oil spill incident, removal and removal cost, and restoration of the environment as far as practicable, and for any cost arising therefrom or connected therewith. It seems
Now,
like that is also subject to misreading by a lot of folks out there.
I would challenge any one of them to find a liability clause in a like legislation that is as broad, embracing, and encompassing as the language here. Many countries cap liability.
Right.
Many countries limit liability. We have removed, well, not removed, we have not put any strictures of any type, no conditionality, no reservation whatsoever. Where the damages run, liability follows. That's the principle here. And it is in accordance with the polluter pay principle and international doctrine. A responsible party is liable for all damages caused by an oil spill incident. The removal and the removal costs as well. And the restoration of the environment. There's different things you're talking about here. As far as practicable. And for costs arising directly or indirectly therefrom and in connection therewith. I don't think that it is possible to express it in wider language than this. And you get the criticism that somehow this nullifies, it overrules, it renders the parent company guarantee and all the other guarantees obsolete. My friend, I can't answer that. It is that you asking me to explain why this is not an aeroplane, this piece of wood. It will take me 5 years to explain that. So I don't know the level of interpretative gymnastics that are being engaged and the acrobatic construction that is put to these simple English words that could lead to the perversities that are being published about them. One other commentator, I guess, wants to show that he knows about Guyana's international obligation on these matters. So he came up with another originality. that the bill doesn't take into account Guyana's international obligations and Guyana's the international treaties that we have signed in relation to this matter. So this man thinks that the Attorney General, the Chief Parliamentary Council, and all the young professionals who drafted this bill are ignorant of our international obligations, that we sit down in a cocoon and we draft laws in isolation and in abstract and with no reference to Guyana's international context. We are not like them. Maybe that's how they do their work. So they are judging others by their own standards. This bill, first of all, accords with the international legislative protocols on bills of this type. I have said to them that the part that they are criticizing this bill for, or the part that they find critical about this bill, let them find a counterpart section in another country's law of the same type that accords with their requirement. They have some requirements that they want the bill to contain. They want some concepts that they are claiming should be in the bill. Well, let them find a law that mirrors what they want. They can't. I'm telling you that they can't. Because they make up these things. The things that they talk about, they sit down in their quiet moments and they make it up. And they get a willing press in the Kaijo News to give them a front page coverage. And they end up with celebratory sobriquets like international lawyers. So that they say that we didn't. The truth of the matter is, in legislation, in municipal law, as compared to international law, of which treaty is part, you are not required to list all the treaties or all the international law issues that are relevant to the matter that you are drafting a local legislation in respect of. Which legislation you know on any given matter that lists Guyana's international obligations or lists our international treaties on the matter? Unless the legislation that we are drafting is a product of the international treaty, only then you really make reference to an international treaty. So you have the Hague Convention, which we have signed. Out of that comes a number of pieces of legislation. And we have been enacting them as part of our treaty obligations. It's only then that you make reference to the international obligations. But here we have said it. Look, Clause 10. Let me go to Clause 10 quickly of the bill. The responsible party shall prepare, in the case of a facility oil spill contingency plan. There's a party got to prepare the plan. And in the case of a vessel, a shipboard oil pollution emergency plan, which shall be approved by the competent authority in consultation with the EPA, the Ministry of Natural Resources, and Guyana Energy Agency. All these parties are parties to international obligations. When they are examining a plan, they have to ensure that it accords with their international obligations. Like, for example, you have maritime thing, right? A maritime thing dealing with maritime treaties dealing with oil pollution in particular. We are aware of that.
Absolutely.
We don't have to incorporate it here expressly. It says here, the details of the minimum required content of the oil spill contingency plan and shipboard oil pollution emergency plan and the procedures for their approval shall be prescribed by the regulations. So all of the details are coming. And this is the important part. Notwithstanding the provisions of subsection 2, a facility oil spill contingency plan and a shipboard oil pollution emergency plan shall be aligned and implemented in conjunction with the provisions of the National Oil Spill Contingency Plan. As a national plan, there must be a relationship, a consistent relationship. and where practicable, regional and international oil spill response plans developed pursuant to regional or international instruments ratified by Guyana. So all these plans, all these standards, all these protocols, all this regulatory framework that we are keeping, that we are establishing, at the end, they must comply and be developed pursuant to our regional or international instruments ratified by Guyana. And there's a gentleman writing, possibly to show the public that he knows a couple of things about international waters and international pollution practices, and says to the public that we don't know about it, so we didn't make reference to it.
One last one that I want to cite that I've come across this, whether you want to respond to it or not, but that the government, pushed this bill through the House that to tamper with the decision made by Justice Kissoon regarding the U.S. $2 billion parent guarantee.
Absolutely not. Justice Kissoon's decision has been appealed. One of the first decisions that the appeal court has made in that case was to order the lodgement of a $2 billion guarantee. That in that way, the judge is indicating that the unlimited guarantee that the rule upon at the court below doesn't seem to be something that exists, a position that I've held all the time. So he has limited the guarantee to $2 billion. My friend, it's insurance and assurance that you're dealing with.
Yeah.
Right? And that's why we use the term comprehensive. That's what the industry uses to capture the widest possible type of liability.
Yeah.
Right? And that is the formula that we have used. And we will see how the court rules. We have appointed a number of appeal court judges, and I'm pleased to have received information to say that they are fixing new matters already. So these appeals are going to be heard very quickly.
Yeah.
And we will be edified as a country. So there's no need to speculate on those matters. But we have, this bill has nothing to do with Justice Kissoon's ruling. Right? We don't if we want to overturn a judge decision by legislation, we will do that. But this doesn't do so.
Yes.
It doesn't do so.
So I want to end by, to set this bill in context, is give me a bit of a history. And now that it has been passed, I want to ask you to put it in context of where we are now with this legislation, this piece of legislation being passed and becoming law and enacted. Where does the Guyanese people, the people of Guyana, the environment, philosophically, where are we at right now with this bill?
So, as I said elsewhere, this bill was not passed in a vacuum, and it doesn't exist in a vacuum. So we are a major producer now in the oil and gas sector. And from 2020 to now, we have passed some major pieces of legislation in relation to the sector. There were none before. So we passed a local content law that ensures that Guyanese get employment in the sector as a matter of law. Once they are qualified, they must participate in the sector. We have put a formula in to ensure that Guyanese companies participate not equally, but dominate the sector once they have the wherewithal to function in the sector, once they can produce the goods or offer the services that is required. The objective of that law is to ensconce and entrench Guyanese employment, and it has been massively successful. Billions of US dollars have been invested in the sector by Guyanese and are generated in the local economy as a result of Guyanese participation. We have thousands of companies now, I think, participating. In that regard, we are now building a school, a training school in Port Morant to supply the industry. We are building an industrial complex at Enmore on the east coast of Demerara, particularly to supply the industry. Then we passed a petroleum activities bill. The law that we had before was a 1986 law. The PNC, APNU, AFC, after they lost the no confidence motion, they passed, no, they didn't pass that law. They passed another one, which I'll deal with. We passed the Modern Petroleum Activities Act. The one that was there was in 1987. It didn't cater for an oil-producing country. In 1987, we were not producing oil. So we have a modern, comprehensive framework to regulate the industry itself. Then we have the Natural Resource Fund, where we have a dedicated statute and legislative framework to receive the money generated from the sector, to put it in the consolidated fund, and to take it out in a transparent way by the Parliament, have it approved by the Parliament for stipulated types of projects only for national development. And we have an infrastructure that manages the fund and accounts. All receipts are published in the official gazette and are disclosed in the National Assembly. And of course, all expenditures are approved by the National Assembly. That framework was examined and praised by the World Bank and by the IMF as forward-looking, as transparent, as strong, and as accountable. Then we put out there new PSAs. You know, we were dealt with a lopsided agreement. When we got into government, that was signed. And that is not being negotiated. That will not happen again. So we put out there a new PSA, a model PSA, that we consulted widely on. Even the commentators, critical commentators in the sector, have had very little criticism, if any at all, in relation to this new PSA. A new regime of revenue and a new regime of taxation, etc., that would be governed by this new PSA. Then we have this bill. This now deals with the protection part of the industry. And as I said, it meets all the international standards. And we have regulations that will come. And then, Nazim, all the documents that are relevant to this sector are public. I was telling the Vice President the other night, actually he was telling me, that we have disclosed more documents in one given year in relation to this sector than the APNU AFC disseminated in 5 years. Mm-hmm. You know, all this environmental permits and everything, they're all online. If you see the size of the permit, the parent guarantee that they're clamoring about, all of that is there. We ensured that we put that in the new licenses. The capstack apparatus, we put that in Yellowtail. That's it's a machine that used to be, it was never in this part of the world, although you had Trinidad pumping oil for 100 years. It is to come in to deal with an oil spill. We have that one physically present in Guyana. Right? We never had that before. We put that as a condition of the Yellowtail license, that they must have that equipment here. Other than that, we had to wait about 14, 15 days for it to come from Houston, Texas. One is in Guyana. The only one in this hemisphere. Wow. That is what we have done. So, in conclusion, I would like to assure Guyanese once again that we may not have the perfect regulatory framework, and perfection is elusive in my view. But we have strong, modern, transparent, resilient, robust, and a framework that meets international standards. And I challenge anyone to contradict me on these matters.
Yeah. Anil, thank you very much, Attorney General, Minister of Legal Affairs. It's a pleasure always speaking with you, and thanks for clarifying all these issues.
Thank you very much.
Thank you.